just like a 17 March of 2022 and 8 March of 2024 at a known place in Republic of Kenya, jointly with others not before the court, conspired with intent to defraud Kenyan farmers, sold a total of 139,688 bags of 25 kgs each of soil amendment and conditioner valued at Kenya shillings 209,532,000. For accused number, that is Joseph Muna. Joseph Muna, yes. The 2003, the particulars. On 31st March of 2022, at the Kenya National Cereals and Produce Board headquarters in Nairobi City County, being the managing director at the National Cereals and Produce Board, used your office to improperly confer a benefit to Josiah Kariuki Kimani by executing an agency contract between the National Cereals and Produce Board and 51 Capital African Diatomite Industries Limited to supply 139,688 bags of 25 kgs each of soil amendment and conditioner branded as fertilizer within National Cereals and Produce. Fraud number 8 for accused number 3, that is John K. Plagat. Abuse of office contrary to section 46 as read in section 48 of the Anti-Corruption and Economic Science Act number 3 of 2003. The particulars are that on 31st March of 2022, at the Kenya National Cereals and Produce Board headquarters in Nairobi, within the Nairobi City County, being the corporate secretary at the National Cereals and Produce Board, 51 Capital African Diatomite Industries Limited to supply 139,688 bags of 29 kgs each of soil amendment and conditioner branded as fertilizer within National Cereals and Produce Board depots across the country. Your response, Joseph?
Your Honor, not guilty.
Count number 9. That is for accused number 4. This board headquarters in Nairobi City Council, being the chairman of the Business Development and Advisory Committee at the National Cereals and Produce Board, used your office to improperly confer a benefit to Josiah Kariuki Kimani by recommending for an agency agreement between the National Cereals and Produce Board and 51 Capital African Diatomite Industries Limited to supply 139,688 bags of 25 kgs each of soil amendment and conditioner branded as fertilizers within National Cereals and Produce Board depots across the country. Your response?
Your Honor, not guilty.
We also pray that they be admitted to bail. And Your Honor, we draw guidance from what the High Court had determined on the 3rd of April, being that the High Court, in estimation of the whole matter, found the sum of 100,000 cash bail as viable security.
Investigations are complete. That is as per the Director of Public Prosecution press release dated 30th April 2024. That is the Director himself, the DPP, who has said that. I've given a copy to that. So anybody telling you that investigations are going on is not true. Number 2, Your Honor, anybody raising an issue that these are powerful people and they make interference with witnesses. You have given an authority, do it Sagari. I'll give it a copy to the court. That is criminal case number 61 of 2012. Public was Dwight Sagari by Justice El Lagat Kori. And the pronouncements are very clear.
And the second one is recommending the supplier to make the supply. Your Honor, we pray that it significantly occurs to you that in none of the counts is it alleged that the three accused made any personal benefit from the transaction. Secondly, Your Honor, that both the events of executing the contract and recommending the suppliers was within the course of their duties, and they did not go out of their way to procure a situation where, as the judges say, the farmers were misled. Your Honor, the second issue I wish to highlight is that these investigations have been going on now for about 3 months, and the three accused have cooperated very closely with so many investigative entities. The investigative entities, Your Honor, include the DCI who have brought this case, the National Assembly responsible for agriculture, and the Senate responsible for agriculture. They have cooperated with all of them, attended all the collabs, and supplied all the documents that were asked for of them. And we pray that that cooperation be factored into your consideration of the admission to bail.
In section 123, 1A of the Criminal Procedure Code, Your Honor, we are alert to the fact that rights to bail is an alienable right that can only be restricted by this court. And therefore it is not absolute. There are compelling reasons as to why you're opposing this bail. And most importantly is the interference with the witnesses, the likelihood of interference with the witnesses, suppressing of the evidence, or tampering with the evidence. The accused persons before court are employees of the National Cereals and Produce Board, where the prosecution key witnesses are staff and also their subordinates. One may ask that I have not stated which witnesses that they'll interfere with. They're definitely going to know these witnesses. As Mr. Omari rightly said, that investigations are complete. So we'll be ready to supply them with the evidence and the witness statements. The issues raised by the prosecution counsel in opposing the said application. And I've also considered the law governing the issues raised by the prosecution counsel, and I do hereby order that accused person 1, 5, and 6 attends court on the 6th of May 2024 at 9 a.m. for purposes of plea for failure to reach a warrant of arrest is issued. Secondly, this ruling has been printed by the application made by the prosecution counsel, Ms. Onuma, urging the court to deny accused 2, 3, and 4 bail on the basis that they are a flight risk and that they are likely to interfere with the witnesses for the state and for the accused persons 2, 3, and 4, and the authorities provided to buttress their respective cases, and I find as follows. Number 1, that the prosecution has not provided evidence that accused 2, 3, and 4 have attempted to flee the country or that they have avoided the investigation agencies at any given time. Number 2, there is no evidence provided by the prosecution that the accused persons 2, 3, and 4 have interfered with the witnesses. And this court believes that what the prosecution is relying on in their submissions is based on speculation. Number 3, that bond is a constitutional right of the accused persons as enshrined in the Constitution of Kenya, unless there are compelling reasons which the court finds that has not been provided in this matter. The state has provided mechanisms aimed at protecting witnesses who are believed to be vulnerable or who are likely to be threatened and or interfered with. And should there be need in this matter, the court is directing the Office of the DPP and the other investigative agencies to utilize the same and to protect the witnesses who are likely to be interfered with. In the circumstances, I do hereby order as follows. Number 1, that accused 2, 3, and 4 to deposit their travel documents and or passports with the court within 7 days from the date of this ruling. Number 2, that accused 2, 3, and 4 shall inform the court and or seek the permission of the court whenever they wish and or intend to travel out of the jurisdiction of the court and out of the borders of this country. Number 3, that accused 2, 3, and 4 to appear before the investigative agencies together with their counsel and their advocates whenever they are required and to provide information needed by the state agencies that is aimed at aiding the state investigations that are said to be ongoing. Number 4, that accused 2, 3, and 4 are hereby granted bond of 3 million shillings with one surety of a similar amount each and or cash bail of Kenya shillings 1 million each.